We're ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Dukes. Mr. Dukes, please state your name for the record.
My name is George Lee Dukes.
Your Honor, today is the date and time set for the probable cause conference. I'm just looking at Ms. Hughes' email. Thank you, Ms. Hughes. And I think this is something that we could work out. I don't know that we will, but I think if we adjourn it for 1 week, we may find out whether or not there's an offer that can be made. So it's something we're working on. And
I think you can work it out if you'll be reasonable.
Well, everybody knows. I'm the most.
I'm just throwing my 2 cents in. I mean, okay.
Well, I'm working with Ms. Hughes. He's known for being reasonable. I think we could possibly work something out.
All right. So you want the 31st?
Yes, please. Mr. Dukes, you understand?
Pardon me?
You understand what's going on here?
Yes, I do.
All right. Very good.
Probable cause conference will be adjourned August 31st, 2023, 9 a.m. Bond continued.
Thank you very much, Mr. Dukes.
Can you ask him for a PR? I
certainly can. Your Honor, my client would like me to ask you for a PR bond in this matter.
Because I'm supposed to get a shot. I work with CMH and I'm supposed to get a shot Tuesday. I should be able to get the shot. I live in town. I will return. I was in the hospital.
Mr. Dukes, go ahead. Let me handle this part. I got you. Okay.
I apologize.
No, that's all right. That's all right. I appreciate your enthusiasm. And I'm sure the judge does too. So, Mr. Dukes had an issue getting here. He was in the Haverwick program since mid-July. Once he was released from there, he was at the U of M hospital where he was picked up and brought in. I don't believe that he really knew when his next upcoming court date was, which is why he was not here for his most recent court date. As he stated, he lives here in Ann Arbor. He has no place to which to flee. This case is the alleged taking of food from a hospital without paying for it and an ensuing struggle for that food afterwards. We would respectfully request that the court consider granting my client a PR bond in this case.
Any response from the people?
Yes, Your Honor. First, can you see in the file, I don't have it noted in my file, what his bond originally was set at his first arraignment. I
think it was set at, I just saw it. I think it was a PR. Wasn't it?
Okay. I know he's in on.
Yeah, it was a 5,000 PR.
Thank you. That helps me with my argument. Thank you, Your Honor. He's in on 10,000 now for his failure to appear on July 13th. At the original arraignment, my office's request was 10,000, which is what he's in on now. What Mr. Brown said is correct regarding the facts of this case, but the reason this is charged as an unarmed robbery case is because when the defendant stole food from the University of Michigan cafeteria, an employee saw him and started to proceed after the defendant, telling him he had to pay for the food. Interestingly enough, the defendant responded that he's an official taster of food. Perhaps that's why he was engaging in what he was engaging in. However, when the employee continued to follow him to get him to pay for the food, the defendant asked the victim, "Do you want to be clocked?" and then proceeded to punch him in the face 2 times, leaving him with injuries to his lip. That's the reason this is an unarmed robbery charge. The defendant has 4 felony convictions. Most of those are theft crimes, including larceny in a building, larceny from the person. In addition to that, he has 4 misdemeanor convictions for assault, and 2 of those are aggravated assault. At the time that he was arrested for this unarmed robbery, the police report says he had an active arrest warrant for an assault in Ann Arbor. That might be a city case because I don't have access to that file to see what that's about. But again, my office's initial request was 10,000, and that's what he's in on now. So we're asking that his bond be left as currently ordered.
In brief response, Your Honor, these facts would have been known to the magistrate who set the bond. And the real difference here is that he failed to return to court. Again, there's an explanation for that. There's a reason for that. He had been in the Haverwick Hospital and he didn't get released until after his court date would have taken place. So we're asking that the original bond be set as his failure to appear in court was not something that was intentional by him. He did not intend to not follow the court's orders.
I'm going to deny the motion for bond reduction at this time. We're set out in a week, and maybe I can get some updated information regarding his communication and treatment through CMH, which would that may have been part of the basis for what happened in the case. And I realized there was the violence involved, but I would like to make sure that the individual is, I guess I'll say, stable, or at least under the supervision of somebody prior to release.
I understand.
Okay. All right. So it's denied at this time. Bond will continue. Thank you.
Thank you.
Thank you.
Court calls the case People versus Jason Bryant.
Ready, Judge.
Nicole Hughes on behalf of the people.
Portia Feaster, Assistant Public Defender, on behalf of Mr. Jason Bryant. Mr. Bryant, please state your name for the record.
Jason Bryant.
Thank you, Judge. I have spoken to Ms. Hughes on this matter and to Mr. Bryant. I believe this is the first PCC. He's just asking for a 2-week adjournment so we can try to reach a resolution, Your Honor.
Probable cause conference in this matter will be adjourned September 7th, 2023, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you. Court does call the case of the People versus Corey Brooks.
Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the People.
Good morning.
Emily New on behalf of Corey Brooks. Mr. Brooks, can you please state your name?
Good morning, Your Honor. Corey Brooks.
All right. And what are we doing on this case, folks?
Judge, it appears that Mr. Brooks has paid his child support arrearage in full, and that it's highly likely the case will be dismissed. However, and Ms. New did just this morning, I got an email. It's not from the MISIS system saying that we know that he made the payment, but it hasn't showed up yet on the system. So I'm still looking. We were going to look for a couple-week adjournment. I think we can send a nollie prosecute. We should get the information if it was on the system, the system that he used to pay. We should get the information within the next day or two on the MISIS system, and then the AG. I'll just have him shoot a nollie prosecute. That's my understanding, Ms. New, correct? Because I didn't see in Mr. Awada Coker's notes that it was going to be a dismissal. Normally, he still has to plead to a simple misdemeanor, but my understanding is you have an agreement that it's going to be an outright dismissal, correct?
That is correct.
Okay, so we're just looking for a couple weeks, Judge, and then this case will go away.
All right. Well, hopefully the holiday won't delay it. I'll adjourn probable cause to September 7th, 2023, 9 a.m. Or as your Zoom invite indicates, bond will continue. Thank you.
Thank you, Judge.
Court does call the case of the People versus James Lee Trussell.
All right, let me turn this down towards you.
Your Honor, good morning. Jonathan Emmons on behalf of the People. I did see Ms. Diallo logged in earlier.
Ms. Diallo? She's not here.
No, she was. I did.
She was here, but she's not now.
Yeah.
Well, that's not good. Can we see if we can, Mr. Evans, let me briefly pass it. Let's see if we can find her, because I can't go forth. I think she's requesting a competency or forensic. I can't do it without her present.
Thank you, Your Honor. Yeah, I can obviously stay put.
Okay. So you just did?
Yeah.
Okay. All right. We emailed her and see what we can do. Court does call the case. People versus Camu Carter.
Nimish Ganatra for the people.
Good morning, Your Honor. Gina Noveski, First Assistant Defender, with and on behalf of Mr. Carter, who is present from the jail.
Mr. Carter, can you state your name, please?
Kamal Carter.
Okay, there he is. All right. And I have a plea form in front of me. Is that what we're doing today?
Yes, sir.
Yes, it is, Judge.
Okay. All right. All right. Plea form indicates that the defendant will be pleading guilty to counts 3 and 4. Count 3 being attempted resisting and obstructing a 1-year offense, and count 4 being refusal to obey a traffic order. That's a 90-day misdemeanor. Upon a successful plea to those charges, counts 1 and 2 would be dismissed. There's also an agreement that he agreed to plead to the child abuse 4th and DV and 14A cases before me, and I think that's been done.
It has.
Yeah, because I'm getting sick of Mr. Carter. No, I'm just kidding. I've seen a lot of it. I'll just put it that way. I didn't mean sick in the bad way.
I know what you mean.
Okay. Okay.
Your Honor, that's the people's understanding of the plea agreement form. Thank you.
Thank you. All right. Mr. Carter, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. State your name again for the record, sir.
Kamal Carter.
All right. Sir, it is this court's understanding that you're going to be pleading to 2 misdemeanor charges. Count 3, the attempted resisting and obstructing, is a misdemeanor punishable by up to 1 year incarceration, and I think it's a $1,000 fine plus court costs. Isn't that correct, Count? This says 2, but I think it's a 1 year, $1,000 fine plus court costs.
Yes, I believe you're correct.
All right. You understand that, sir?
Yes, sir.
And also that you'll be pleading to an added count 4 of refusal to obey a traffic order. That's a misdemeanor punishable by up to 90 days and a $100 fine plus court costs. You understand that?
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty?
Yes.
Well, I should also advise you that while I'm taking your plea in this case, I would not be your sentencing judge.
Your Honor, we were actually hoping not to waive sentencing, Judge, so that you could sentence him on all of his cases.
Oh, man, really?
Yeah.
This one
He has
last
sentencing
time.
on 9/11.
Yeah, I want to. Man. Okay. All right.
All right. Thank you.
I'll do it. All right. So understanding all of that, Mr. Carter, do you still wish to plead guilty?
Yes, sir.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
To the charge of refusal to obey a traffic order, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you're indeed guilty of this offense, these offenses?
Yes, sir.
April 10th, 2023, at the location of Grove Road and Lakeshore Drive in Ypsilanti Township, Washtenaw County, State of Michigan. Did you come into contact with Washtenaw County Sheriff deputies?
Yes, sir.
Particularly William Kelly. What happened?
He pulled me over. He said you had a warrant. And I just took off.
You took off running? And you knew that
I took off in the car.
You took off in the car?
Yeah, then got out and started running.
Okay. And you knew that Deputy Kelly was trying to arrest you?
Yeah, I ain't
Oh.
feel at that time.
Yeah, okay. And there was a traffic, when you say that you were in the vehicle and you took off, were there lights and sirens behind you at some point?
Yes, sir.
And you knew that them having the lights and sirens on were in order for you to pull your vehicle over.
Yes, sir.
And you didn't immediately pull your vehicle over, is that correct?
Yes, that's correct.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be September 11th.
Do you want to do it all the same?
I want to do it all the same day.
Let me look. That sounds right.
What date?
Except for September 11th.
Oh, that's on the DV docket. That's why
Yes,
it's
the
not.
DD docket. I mean.
Yeah, let's just put him there.
That's fine. September 11th.
September 11th, 2023 at 1 p.m. Is that?
He's in custody.
He's in custody. That'd be at 12 noon. And that will be before me. Let me just mark this so the clerks know it's a special time for this case. All right. Independence bond will continue. All right.
Hey, Judge, I was asking for a bond for this hearing because the only thing that's holding me up is the DV. I was seeing because I remember you said you didn't want to let me out, but you just wanted me to get all these cases together first.
So you're asking, what are you asking for?
A PR bond for the DV or a bond, if that's possible.
Well, I don't have in this case, what do you have as bond in this case?
I mean, you denied my bond on the DV case. That's why,
Yeah, and I'm unlikely to change that without a full hearing. So what I'm going to do in this case is just leave your bond where it is and continue it at this point. Okay. All right. This is actually a PR. No, instead, Mr. Carter, what I'm going to do is because your bond is denied on your DV case, I'm going to set your bond in this case at $1,000, 10%. And the reason I'm going to do that, that's $100. The reason I'm going to do that is so you're going to get credit against this case.
Okay, so could you repeat that again for me? So
your bond on this case was a PR. Okay. You would not get credit for the time that you're in on this case. So I'm setting your bond at $1,000, 10%, basically $100. So that what will happen is you will receive credit for the time that you're in on this case when it comes to sentencing.
So if I was to bond out, I will still be in here?
Well, you're not going to be able to bond out on your DV,
right?
Because I'm holding you on that.
Okay.
I just don't want you not to get credit on this case. So that's why I'm giving you a bond on this case.
Okay. All right.
Okay. Mr. Nebesky, is there any objection to the court doing that? I mean, I think you understand why.
She's having mic issues.
You're having mic issues.
Yeah.
Okay. But let me do it this way. Ms. Nebesky, you can nod or shake your head. Do you agree with what the court has done in that would be in your client's interest? Okay. All right. And they'll be down to explain it to you in a little bit more detail. Okay, Mr. Carter?
Okay.
All right. We'll see you on the 11th.